Good afternoon, Acting Judge President Musi.
Good afternoon, Chief Justice, and good afternoon, Commissioners.
Are you well?
I'm well, thanks, Chief Justice. Yourself?
Thank you. I'm very
Good.
well, thanks. When did you begin to work?
I started to prosecute in the Western Cape, 1986.
1986. Until?
Until 1991, I became a magistrate.
Was your Afrikaans already good, or did you pick up a bit of Afrikaans there?
Well, I don't know what the level really was, but I picked up a lot of Afrikaans in the Western Cape, yes.
And you're now proficient in
Very
that
much
language?
so. Very much so.
Yes. And for how many years were you a magistrate?
I was a magistrate for about 6 years, then I became a regional magistrate, which was also about 5 years.
5 years. And for how many years have you been a judge?
I've been a judge for 13 years. I was appointed effective the 1st of June 2005. I acted for approximately 3 terms before that in the Northern Cape.
Yes. And when were you appointed Deputy Judge President?
I was in 2016, pardon.
Yes. What are the challenges there? And what have you briefly been able to achieve from the time you came in deputizing for the JP?
Thank you, Chief Justice. Firstly, we had a problem with appeals because appeals coming from the lower courts, especially the regional courts, to the High Court was a bit slow. And I then identified the main reason, therefore. What happened is there was a decision that the legal aid, because the legal aid is dominus litis in the appeals, that the appeal should go to the legal aid, and that the legal aid attorneys will then scan the appeals, and if an appeal is ready, they will communicate with the Director of Public Prosecutions, Free State, and the matter would only be set down thereafter. When I inquired, I was told that there are approximately 24 cases at the legal aid which have not yet been processed, and the cases were there for approximately 2 months. I then requested the clerks to write to legal aid so that all the matters should be brought back to the court. When I had a meeting with Ms. Smith of the legal aid, the inter alia informed me that the problem with most of the records is there are a lot of inaudibles. So I said, well, if a record is replete with inaudibles, the people to do the reconstruction are the clerk of the court in conjunction with the magistrate, prosecutor, and the attorney or the accused in cases where the accused are not defended. And I then started a process to make sure that all those matters go back to the district court so that the necessary can be done. And that is the reconstructions, in the sense that the clerk of the court must get the magistrate's notes, the notes of the attorney, if there was an attorney, the accused, and the prosecutor. That was done. What we now have, for an example, on our court roll, which we do appeals on a Monday. We would have only 2 appeals, but the arrangement is as and when the appeals become ready, they must be put on the court roll, and in that way we can eradicate those matters that were at the legal aid. But in terms of backlogs, there are only 3 matters which are at this stage backlog because they were removed previously by legal aid.
Yes. Now, or you can. Did you want to say more?
Yes,
Please proceed.
In terms of the challenges, I've also started a continuous role. In the Free State, we did not have a continuous role in the sense that a matter is set down for 2 weeks. If, for an example, only 1 or 2 days extra are needed to finalize the matter is postponed. invariably the matter would be postponed to the next term or the term thereafter. I have then spoken to some judges, and I told them, and also the legal aid, where the legal aid is involved, that please people, if there's only one day needed, the DPP will call my office, and I will then arrange that the matter rather continues the next week. If it's only 2-3 days and the matter can be finalized, I would arrange for another judge or go to court myself if I'm available.
Yes. Now, you know that the norms and standards require that judgments that are reserved be delivered within 3 months, but just for our own internal processes, isn't it?
Yes.
So that if you haven't finalized your judgment within that period, the head of court can then approach you and say, watch out, you're going towards the dangerous zone. Are there challenges? Do you need time? Now, in terms of Article 10(2) of the Judicial Code of Conduct, then it specifies circumstances under which you may be in trouble if you don't deliver your judgment within that time frame. But that notwithstanding, we still have people taking as long as a year, others 2 years to deliver their judgments. What, in your experience, is a challenge here? Why is it that some judges still take as long as 3 years to deliver a judgment?
Yes, thank you, Chief Justice. Well, I think 3 years is totally unacceptable. There are, however, cases that would go beyond the 3 month period. Yes. But 12 months, 3 years, totally unacceptable. In the Free State, fortunately, we don't have those kind of cases. But I am told that in the busier divisions, especially in Gauteng, it's bad, especially judges who are in motion court. Sometimes they pick up 10, 12, 15 reserve judgments, and the next week they are again in court in civil trials or criminal trials. And as and when they write their judgments, just more judgments arrive or matters arrive, and they have problems writing their judgments. And there are those that would say, well, it also depends on the degree of complexity. I know I've heard judges saying, well, in some cases they would get, the papers would be in Afrikaans. They must preside over such matters, and they would have problems. But those are anecdotal kind of.
Well, we have some who are proficient in Afrikaans with judgments that are outstanding for at least 2 years. So.
Well, sorry, the Chief Justice, as I said, that's totally unacceptable.
Yeah.
Yeah.
What could be done in your view, according to your experience? What is it that should be done?
Well, Chief Justice,
what would you do if you were to be appointed JP of the busiest divisions, for instance?
Well, I already have a system in the Free State which I think can be replicated in the busier divisions. What I have is every Monday I get a complete list of reserve judgments, and it's color-coded. The red ones are those that are older than 3 months. Then they have the orange ones and the ordinary white ones. The orange ones would be those that are 2 months and going towards the 3 months. In those cases, I approach the judge personally. I call the judge and say, well, look here, your judgments are now in the red, literally in the red. We can't have that. What is the problem?
Yes.
Judge tells me what the problem is. I then say, well, is it possible for you to deal with at least these ones that are in the red within the next 2 weeks or 1 week? And I monitor it in that way. Every Thursday, we have motion court, and the tradition in our division is that reserve judgments are delivered on the Thursday. The registrar's office, by 11 o'clock on that day, sends me a list of the judgments that were delivered. I then update my list, and if, for example, a judge has promised to write a judgment or deliver the judgment on that Thursday and it has not been delivered, I go to the judge and I tell the judge in no uncertain terms that it's totally unacceptable. The judgment must be delivered by tomorrow or whenever, depending on what the problem is. But the minute that a judge promises that a judgment will be delivered the Thursday, I keep the judge to it.
Yes. Now, judges president play a supervisory role over the magistracy
Yes.
in their respective provinces. And you know that it tends to take a bit long before cases are finalized in the magistrate's court. And with your experience as a magistrate, I then asked you to assist with a compilation of credible performance related statistics. What are the challenges briefly with the magistracy? What is it that causes the delays, and what is it that needs to be done to move us from there to an acceptable level of performance?
Thank you, Chief Justice. You would recall, Chief Justice, that the first problem which we identified was that there were no set and discernible key performance indicators, firstly. Secondly, magistrates would receive cases. The matter would first go to the channelization court. Even if a matter is ready for a guilty plea under certain circumstances, the matter would be postponed. In the Free State, specifically the Goldfields region, they have a big problem with illegal miners. The chief magistrate and I then went and I looked at her court rolls because they were just sky high when they sent me the stats. I then found out that what happened is the Director of Public Prosecutions would charge illegal miners for being illegally in South Africa, for being in the mines illegally, but also for attempted theft. Now, normally, if it is a question of being illegally in the country and trespassing, illegal mining, there would be a fine, or in the extreme cases, imprisonment, but immediately thereafter, the person is extradited, is sent back to his or her country of origin. But with the attempted theft being included where there's no real evidence of theft, it is now a question of bail must be set because they don't want to plead guilty on attempted theft because they would inter alia say, well, I'm in the mine shaft to go and sell bread. My reason for being there was not to go and steal, and therefore I plead guilty. In conjunction with the Chief Magistrate, I spoke with the Director of Public Prosecutions and asked them, but in how many cases do you really get a conviction of attempted theft? I was told that it's a very negligible percentage, and I said to them, well, what does the administration of justice gain under those circumstances? If we have situations where people are kept in custody because you can't give them bail, there's this attempted theft case, and ultimately 2-3 months down the line, if the attempted theft case is withdrawn, the person pleads guilty, the matter is finalized, and the person is deported. We then agreed that they would charge them on trespassing and being illegally in the country. That has helped. There was a marked reduction in outstanding cases in that entire region. Yes. With Sasolburg in the regional court, I also looked at the stats. It was clear that there's only one regional magistrate there. It's clear that there's a problem. I physically drove with the regional court president from Bloemfontein to Sasolburg, sat down with the regional magistrate and said, well, this is unacceptable. The stats are just way too high. Whenever somebody else is acting here, there is indeed a reduction. Something has to be done. What can be done? What do you suggest? She then made a few suggestions, inter alia that the court will start earlier and she will sit longer hours. She'll also set down more cases because currently as things are, regional magistrates determine their own court roles. When the system started, it was a good system, good innovation, because initially the prosecutors would set down matters in the regional court for regional magistrates. The regional magistrate now has his or her own diary and sets down matters. We then also anecdotally heard that regional magistrates don't use their office hours optimally. And I said to the regional court president, you will have to physically go to all the regional court seats, look at the stats, and then report back to me as to what remedial steps have been taken to make sure that the court hours are optimally utilized. 3 weeks ago, she sent me an email confirming that she has indeed done so, and during our next PEEC meeting, she will report on whether there has been any positive progress in that regard.
Yes. Is your PEEC functional? Are you able to resolve blockages at that level?
Yes, definitely, Chief Justice. We hold a PEC meeting once every term at least. During the meeting, we obviously have an action log and we give tasks to different role players. And we have all the most of the role players normally under one roof. And at that stage, where a blockage is caused by one of the role players, we normally have the decision maker, like if it's in the province, you'll have the provincial commissioner. We will have the representative of the Premier's office. We will have the director or chief director, basically, of social services there in terms of juveniles and juveniles in custody. So after the PEC meeting, we expect action, and normally they report back. They report back directly to me, and I make sure that before the next PEC meeting, they give reports, and those reports are disseminated to all the stakeholders, and people are interrogated on the reports themselves and why they did not action on certain things which the PEC requested them to action.
If you add up all the entire period during which you acted as judge president, what does it come down to?
Approximately 6 months when the former JP acted in the Constitutional Court, as well as an additional 6 months when she acted in the Supreme Court of Appeal, and I've now acted from the 1st of June. So roughly it's a year and about 4 months.
Yes. Are you, well, maybe it's a rhetorical question, let me avoid it. Now, you are the one responsible for basically allowing us or disallowing us to have a salary raise. Will you be, if appointed, will you continue in that capacity, or are you going to have to relinquish the responsibility?
Well, Chief Justice, with our current economic situation, I don't know whether it's a good or bad thing to be that judge, but my tenure ends next year, October. I am now in the middle of comprehensive reviews to review the salaries of the executive, legislature, as well as the judiciary. So I will have to complete those projects at least. But it is not a hands-on thing. I was hands-on when I conducted the interviews of the legislature. I've left it to the consultants to do the executive. Likewise, the judiciary, I've already spoken to Judge Wegley, and we already have tentatively worked out how the thing will pan out. And when it comes to the magistracy, it is the Lower Court Remuneration Committee. They will also be consulted in that regard.
Yes. Acting Deputy Judge President Van Zyl, any questions?
Thank you, Speaker. Good afternoon, Judge Musi.
Good afternoon.
Your mic is off.
Sorry, good afternoon, Judge Musi.
Good afternoon, Judge Marcel.
In the report of the IAWJ, you are described on the one hand as a rare breed of judicial officer, similar to none. And on the other hand, it is also stated that you come with a wealth of experience in leadership. Now, would you say that during this lengthy period of time during which you've been acting as Judge President, that you've been able to balance and successfully fulfill your tasks as presiding judge on the one hand, but as administrator of the division on the other hand?
Thank you, Judge Mansell. Yes, definitely. I think the IAWJ was very kind, or too kind, in their comments. No, I do balance it, as you know. I go to court regularly. In fact, there's no week that goes by that I'm not physically in court, and I do everything. I do trials, criminal, civil trials. I do opposed motions. Yeah.
So you carry your weight fully with regards to the court role on the one hand, and at the same time fulfilling your administrative functions on the
Yes.
other hand.
Well, when it comes to administrative functions, I think it should be contextualized, because as a judge president, most of the administrative functions are case allocations. And when there are problems with special allocations, parties will come and see you. And for that, I'm always available. I'm early at the office, and I leave late, as you know. So it's a question of time management.
Thank you. Then in her letter of nomination, our erstwhile Judge President, Madam Justice Molamela, inter alia made the following statements, and I'm just going to read it to you to refresh your memory. He is a team player and he has earned the respect of all the colleagues in the division, as well as the stakeholders in the justice cluster in the Free State province. A continuation of his cohesion is obviously of crucial importance in maintaining the stability of the division. Do you agree with this statement, and how would you describe your relationship with your colleagues and with the other stakeholders within the province?
Thank you. Well, I have an excellent relationship with my colleagues, as well as all the other stakeholders, especially members of the organized profession. I have had no problem with the bar, neither have I had a problem with the sidebar. My colleagues know that when it's time to work, it's time to work, and I do not suffer fools gladly. As you are aware, there were incidences which I perceived at that time to be somewhat racist and inappropriate, and I challenged the colleagues right there in the meeting.
You were appointed in June 2005. I was appointed in February 2006. So we've come a long way, and I've always experienced you as a very approachable colleague. At the same time, since you've become part of the leading team, or the leadership team of the division, we also became accustomed to your open door policy. Should you be permanently appointed, is there any reason why your management style will change in a way that might jeopardize the respect and good relations you currently have with both your colleagues and the other stakeholders in the division?
No, it ought not. Firstly, as you also know, my management style has never been disruptive. It has always been more facilitative. And that is why all the changes that I made were incremental changes. There's no reason why it should change.
Thank you. Thank you, CJ.
Thank you so much, AJP. MEC Mashinini?
Thank you, Chief Justice Sabona Baba.
Sabona Baba, kunjani?
Chief Justice, from our side as the provincial government, we want to make the following submission. One is that, in our view, the candidate fits very well
MEC, there's a reason why they are,
And Yabona
Yeah,
Okolo.
yes.
I can see everybody's.
yes. It's time for questions.
Okay.
If any.
No. From our side, if Judge Musi can just tell us broadly, just shortly, about the experience that he has gained to be a judge in Lesotho, for an example, just briefly.
Thank you, MEC. Well, I've sat on and off in Lesotho on the High Court bench. I've sat in their Constitutional Court because their Constitutional Court consists of 3 High Court judges who are then appointed to sit in the Constitutional Court there. I have sat in their Labour Appeal Court as well as their Commercial Court. The experience with regard to the manner in which papers are drafted has always been a struggle, but the practitioners there are also always timelessly at court. There was a big issue, though, with advocates taking direct instructions from the public, and as you know, they don't have a system of pupillage as such. After LLB, you go and you practice. And many of them hold chambers at different places. I, in fact, penned a judgment where the issue was exactly whether advocates may take instructions directly from the public.
The area of Velko, Machabe, the illegal mining, quite correctly so, the charges placed to many of those people there are basically the trespassing and also the issue of the illegal mining.
Yes.
What is this thing that we can do better in the Free State to try and stop that? Because if you look at the repercussions in that area, number of people getting killed in that area. What is this thing from a judicial point of view? What can be done better to try and reduce that situation?
Well, for the judiciary, it's a bit difficult because we only deal with the people when they are brought to court. I was told by the chief magistrate that the magistrates in the Welcome area have made many suggestions relating to the absolute closure of the old shafts. Because what happens is the old mining shafts are not closed down properly. The illegal miners then get into those shafts, and some of them stay in there for 3-4 months. And as they go in, they create other exit and entry points to the extent that you don't know where they enter, you don't know where they exit. A month ago, whilst 2 months ago, whilst investigating this whole thing, I was told that some of them now just decide to give themselves up to the police. And they don't know what the reason is. But the speculation that it's because of the turf wars down there in the mines. Because people get killed in those mines, because you go and you mine at a particular place, the rivals come and they shoot them.
What is the impact of delay of cases with regard to people after having involved in the illegal mining and then they cross the border and they go into Lesotho? Don't that have an effect on the delay of the cases?
Well, a delay in the sense that warrants of arrests are issued and the matter basically then stays in the system. But what has happened now is people who are charged with illegal mining or trespassing and being illegal in the country are not given bail. They are kept in custody until the matter is finalized. So thereafter, it is up to the Department of Home Affairs to take them back. But as you also know, MEC, our borders are very porous. And especially when it comes to Lesotho, South Africa, you basically just cross the Caledon River on foot. There's no fence, there's nothing there.
Thank you, CJ.
Minister?
Thank you, CJ, and good afternoon, Justice Musi.
Good afternoon, Mr. Minister.
If I'm allowed first to declare that we do have an acquaintance by virtue of the conferral relationship we have in your capacity as head of the Public Office Bearers Remuneration Commission,
That is correct.
which I must say has been very cordial and all other positive things, to say the least. The PECs, as you correctly describe, play a critical role in streamlining processes that would lead to speedy finalization of matters by ensuring all the role players come to the party. What more do you believe can still be done through that system to enhance the efficiency of running of courts and speedy finalization of matters based on your experience?
Thank you, Mr. Minister. Firstly, one should look at what I would loosely call the turf wars between the police and correctional services, because the police are responsible to take prisoners to courts and from court when they are awaiting trial, and when they are sentenced prisoners, it is something that falls squarely in the purview of correctional services. But those people are held at the same prisons in most cases. Recently, last week, literally last week, a colleague of mine sat in Kroonstad. What then happened is there were accused persons who were held at the Kroonstad prison, but they were in the awaiting trial section. One of them was indeed a sentenced prisoner. The van came to the court with the one sentenced prisoner, left all the unsentenced prisoners at that prison because it is not their responsibility. The police, on the other hand, said, well, we don't have transport to take these people to court. So at the PEC level, one would then ordinarily take up such issues and find out how there can be cooperation and synergies between these different departments. But what we find, Mr. Minister, is that the Department of Public Works or Public Works Department does not come to the party most of the times. To the extent that I have, as in my capacity as chairperson of the PEC, wrote to the chief director of the province, and I copied the minister, the Honorable Mr. Ngesi, to complain about that, because many courtrooms don't have proper court cells. Police stations don't have court cells. I recently went with the chief magistrates of Bloemfontein and Welkom to all the courts that are housed in police stations. There too, it was shocking what I found there. And the constant refrain was, we have written to Public Works Department, we have written to the Public Works Department, nothing is happening. So in terms of the PECs, what we have resolved is the matter must be escalated to the NEEC and put on the NEEC agenda. 2, in order to make it more efficient, if a provincial role player does not play his or her role, the matter must be escalated to a national level in order to make it more efficient.
Maybe a small request from my side would be if I could be copied some of these reports from the PECs, maybe we'll establish a mechanism so that we are aware, and because many of those institutions do report to us in a way.
Thank you, Mr. Minister.
Yes. The over and above dealing with some of the practicalities that result in delays in the finalization of matters. Just in terms of promoting efficiency in the justice system generally, to what extent do you believe that other measures other than formal judicial processes could serve to achieve justice extrajudicially and therefore reduce the burden of the court system to have to deal with every other dispute, if at all?
Thank you, Mr. Minister. ADR, as you know, has been explored in terms of court-annexed mediation. Unfortunately, by most accounts, if not all accounts, it is not successful. The reasons proffered for its failure are also varied and diverse. Many say, well, the attorneys are also not really embracing it, and they are to some extent averse to it. The other problem is who pays for the mediator. Do we have skilled and qualified mediators? All those problems plays into it, and it makes the pilot projects fail, and we are waiting for the rollouts, but as you know, Mr. Minister, the rollouts don't happen because the pilots implode in most cases. So what we can do is to see whether we can try and resuscitate, as it were, the ADR system of court-annexed mediation. But we should make sure that the system is of such a nature that, one, in the civil cases, the judicial officer must also play an active role to say, well, shouldn't this case go to ADR? Then get the mediator tries to mediate the matter. If it can't, then it can't. In terms of the criminal matters, Mr. Minister, we have the diversion system. Magistrates are complaining that when it comes to diversion, the prosecutors will sometimes wait for the date of the trial and then say, well, we can't deal with this case now because the parties have been sent for assessment to see whether the accused can be diverted. So that in itself then becomes a waste of time. How can we address that? Maybe we should think about having a more structured approach, either by way of policy from the NDPP to the prosecutors as to when people should be assessed for diversion, and I think definitively tell them that it should not be done on the trial date.
No, I think that that would certainly be useful information as we're reviewing the entire criminal justice value chain framework to look at what it is that is missing in the system that can be improved upon. Hopefully you'll put forward some of those suggestions if prompted to do so.
Well, thank you, Mr. Minister. I'll definitely do so because, as the Chief Justice has already indicated, I am overarchingly in charge of efficiency in all lower courts, district as well as regional courts, from the judiciary's point of view.
Thank you, Chief Justice.
Before I move on to the next, did you send judges and magistrates to attend training on mediation here?
Yes, Chief Justice.
Okay, all
Yes,
right.
definitely.
Commissioner
I was here myself.
Okay, I attended too. Commissioner Nyambi?
Thank you, CJ. Afternoon, Judge Musi.
Good afternoon, Commissioner Nambi.
If you can share with us the special attribute that can make you to stand out to be seriously considered for the position of the JP of Free State Division.
Thank you, Commissioner. Firstly, as you have already heard, from a judiciary perspective, know exactly how the system works. There is the saying that a chain is only as strong as its weakest link. I can identify the weakest link because I've been a magistrate in the district court, I've been a magistrate in the regional court, and I've been a judge of the High Court for 13 years and a few months. All in all, my experience on the bench is nearly 30 years, the lower and higher court bench. So I know exactly how the system fits in. Secondly, I have seamlessly acted in that division as a judge president, and during which time the stats will show that too. The stats currently of outstanding judgments older than 2.5 months is at 8. Stats of judgments that are older than 3 months as of last week in the recess, 5. And we always have the situation that after any recess, all the judgments must be delivered, and I want full account of it. So I have a hands-on approach as well. I speak the languages that are spoken in the Free State. So even litigants who come there who are at that stage undefended and do not know where to go to, and they are, for one or other reason referred to my office by either the security or the office of the registrar, I can also assist them in any of the languages spoken in the Free State.
What might be your weakness, if any?
Well, in terms of weakness, to some extent, it's a question of wanting to do too much myself. And when I do delegate, I always make sure that I keep an eye on the person to whom I've delegated powers to see that it is indeed done. And in that sense, maybe put too much pressure on the person to whom I've delegated some of my powers.
My last question, it's in relation to the one that has been raised by the CJ about your other role as a chairperson of the Remuneration Commission. What is your understanding if you come with recommendations and the leader of the executive decide to go against your recommendation?
Well, mine is just a recommendation. The determination is made by the leader of the executive, His Excellency the President. So I have no choice but to accept it because my role, per definition, is only to make a recommendation. The decision is ultimately taken by His Excellency the President.
Thank you, CJ.
Thank you, Commissioner Nyambi. Commissioner Didiza.
Thank you very much, CJ. Good afternoon, Judge Musi.
Good afternoon, Commissioner
How are
Didiza.
you?
I'm well, and how are you?
Fine.
Thank
Judge
you.
Musi, I've looked at your form, and also in terms of your expertise and experience, you have been involved on issues of training and transformation, and you also have alluded as you were answering on how you yourself have dealt with an issue that presented itself at a particular time which bordered on racism, as you said. You have had a division that has been headed by a black woman. And you've been acting in that position, and you know that one of the issues that we have raised with respect to transformation has been the issue that relates to the composition in the bench generally, and all in terms of race and gender. And if I may ask you, what would you do to ensure that we see women and black women also in your division?
Thank you, Commissioner Didiza. Well, firstly, it is a question of appointing women as acting judges, which is something that I have done. I have asked the minister to appoint female acting judges. I have constantly done that. I've also done it now. In fact, when I could not find women in the Free State because they had other commitments, it was short notice, I requested a woman from Gauteng to come and act in the Free State. And I've asked her to come back next term to come and act there again in the Free State. So my view is, as a JP, one has to go and look for women, inquire from colleagues, from the magistracy, as I've said in the past, academia, as well as the organized profession.
Thank you very much. The second question, in one of the questions you where it asks whether there is any matter, relevant matter that you want to bring to the JSC, you mentioned two. One, that you are an attorney and the second one relates to your work in Lesotho as a judicial officer. I just wanted to know whether your work in Lesotho, for instance, has it enhanced your work, and which you would find relevant to the work that you do in this country?
Thank you, Commissioner Titiza. As I've said, I have acted in various courts in that country. I have been exposed to their laws. They are indeed different laws, although most of them are similar to ours. There are differences in nuances. One must also look at their precedents. So I have gained a lot. It has changed and broadened my view, as well as my knowledge on how to deal with matters.
Thank you very much, CJ.
Thank you, Commissioner. Commissioner Mpofu?
Thank you, CJ. Good afternoon, JP.
Good afternoon. Not yet. Good afternoon.
AJP. I'm a prophet.
Okay.
Thank you. Thank you. There's one issue that I wanted to raise with you, which was of concern to me as a practitioner the last time I was in your court. Is this thing called the certificate of agency,
Yeah.
which in your court is even, well, there are two courts in South Africa that still have that, you and the Eastern Cape. And I'm just pushing my luck because the last time the candidate for the JP of the Eastern Cape, after I asked about this, he said he was going to abolish it. So I'm hoping to have a 100% record on this question. On a serious note, yeah, it was something that actually struck me as both archaic and quite unnecessary, especially in your court, because it only applies on Thursdays, on the days of the motion, of the opposed motion. Yeah. And the experience we had, I mean, we had 6 practitioners, 3 per side, all from Joburg. We didn't know about that rule, which is, I suppose was our fault. But then we ended up holding literally a full bench for the whole day, debating whether or not there should have been a certificate of agency, which defeated the entire purpose. And needless to say, by the time that issue was decided, the day was gone. And then, fortunately, it had a happy ending in that we came the following week, but now you had to constitute another full bench. So 6 judges really ended up having to do the same thing. But the point really of my question is that the certificate of agency, in my view, and I'd like to hear your comment, really doesn't serve any extra purpose, because I mean, even if you do a certificate properly, you still are going to have to argue agency. It doesn't really get you out of the hook. Is it something that you could look into? I know what the intended purpose is, but as to whether it really serves that purpose, or whether, as I say, maybe I've just had a particularly negative experience of it.
Thank you, Commissioner Mpofu. Firstly, I will definitely consider it. The rules themselves make provision for urgency. You already told us now that you know what the reasons are behind it. Now it's just a question of looking at whether the means justifies the end and see whether it should not be abolished. But as you say, you know what the reasoning was behind it. Thank you.
I do. Thank
Yeah.
you. Thank you, Mr. Chair.
Thank you so much, Commissioner Mpofu. Commissioner Norman?
Thank you, Chief Justice. Good afternoon, Judge Musi.
Good afternoon, Commissioner Nama.
My question really is linked to the one that Commissioner Didiza asked you. She read out to you in paragraph 20 of your application, where you asked, is there any other relevant matter which you should bring to the attention of the Commission? And it's page 7, it's paragraph 20, paginated page 17.
17.
Yes.
Yes.
And you say there, I am an attorney of the High Court of South Africa. I just want to ask you, before I assume that to be correct, is that correct that you're still an attorney?
Well, non-practicing, but I am, yeah. But not practicing.
Are you still on the roll of the attorney?
Yes. Yes.
And since this whole time that you have been a judge of the High Court, you've remained on the role of attorney?
Yes. I've never applied to be struck off the roll. Yes.
Thank you.
Why?
Is it necessary, CJ? Because I'm not practicing as an attorney, so I don't think it is necessary.
You are subject to the disciplinary measures of the Law Society.
No, you are not. No, I don't think so, CJ. Not when you're not practicing.
Yeah, as Justice, you want is a follow-up as a
Yes, Acting Judge President, you have to pay dues every year.
No.
No, you don't.
No, I
Are
don't.
there no dues? Are there no dues called upon by the Law Society?
No. They have not called on me to pay any dues.
No, I mean I don't think it's. But I think it may be wrong to describe yourself as an attorney. I think that's the end. That relationship's ended.
I'm admitted
So-
as an attorney.
Yeah,
That's
yeah,
basically.
yeah. But I mean, you were admitted. But
Yeah.
I don't think you can continue to describe
Yeah.
yourself as well.
Thank you, Justice Nafta.
Commissioner Fourie?
Thank you, Chief Justice. Good afternoon, Judge.
Good
Musi.
afternoon, Commissioner.
I wanted to raise that same issue with you, and there's another one as well. But I'm a bit confused now as to your answer. If I look at paragraph 6 of your questionnaire, page 12, paginated page 12, you therein set out your career path. You say
Yes.
you were a prosecutor, a magistrate, a regional magistrate, a judge, and a deputy judge president. Now, where does the attorney part comes in?
Well, whilst I was a regional magistrate, I wrote the bar exam, and I successfully passed it, and I was admitted as an attorney at the Cape High Court.
Should that not have been reflected as part of your career?
But it's not a work experience. I've never practiced as an attorney. That's why I mentioned it somewhere else. Because what this asked is, please furnish chronological particulars of employment since leaving school. I was never employed as an attorney. I'm just admitted as one.
Just on your reference to I'm an attorney of the High Court, I don't think you can be
Okay.
both. You can't
Yeah.
be an attorney and a judge.
Admitted attorney. I think
And on your CV, I see as one of your referees, you give Judge Tlaletsi
yes.
as one of the referees. To the best of, I know that Judge Tlaletsi is now the Judge President of the Northern Cape, and he used to be the Deputy Judge President of the Labour Court and the Labour Appeal Court.
Yes.
To the best of my knowledge, that position of Deputy Judge President is now vacant. But you still refer to him in your CV as the Deputy Judge President of the Labour Court and the Labour Appeal Court. Is there any particular reason for that?
That might just be a mistake, but
Have you finished, Commissioner Fourie?
I'm just wanting for. Oh, I thought you want to have a look. Are you saying
no,
it's
it's
just
yeah,
a
it's
mistake?
just a mistake. Yeah.
Oh. Thank you, Chief Justice.
Thank you, Commissioner Fourie. Chairperson?
Thank you, CJ. Good afternoon, Judge Musi.
Good afternoon, Chairperson.
I think I heard you earlier on saying you don't suffer fools.
Yes,
which means you also speak your mind.
yes.
So have you ever found yourself compelled to write a dissenting judgment? And was it difficult?
Thank you. And one of the comments here, I think it's by the Democratic Rights Unit, you'll note in 2007, State versus Sarabako, the JP of the division wrote a judgment. It related to whether the rape involved inflicting grievous bodily harm. The JP wrote the judgment, and I dissented from the JP, and the third judge agreed with me, and my judgment became the majority. But it started off as a dissent from the JP, and by then I was only 2 years on the bench as a High Court judge.
Thank you. So do you think that dissenting judgments add positively or negatively in the development of South Africa's jurisprudence?
My personal view is it adds positively because it gives you a different perspective from the same factual matrix or an interpretation of the law. What it actually says is that two people can view the same thing from two different vantage points and perspectives, and then articulate their views and justify why they settle on a particular conclusion, which is good for the development of the law. In fact, there's a saying that today's dissenting judgment becomes the law of tomorrow, because in most cases, the visionaries are the dissenters.
Thank you, CJ.
Thank you, Commissioner. Commissioner Nkosi Thomas.
Thank you. Thank you, Chief Justice. Good afternoon, Justice Musi.
Good afternoon, Commissioner Thomas.
In your questionnaire to us, on paginated page 16, paragraph 19, a question is asked of you. Are there any circumstances known to you which may cause you embarrassment in seeking the appointment for which you have been nominated? Do you see that?
Yeah.
And you gave us a response there. And you said, I've been informed that Judge President Hlophe has lodged a complaint against me. Now, I'm not going to ask you about the merits or the demerits of that complaint. I just want to find out from you, has that complaint been finalized?
No, not yet.
So if that complaint is still pending, wouldn't it be well advised of this body to defer consideration of your application until such time as this matter has been resolved?
Well, I cannot speak on behalf of this august commission, but ultimately your decision.
Well,
You may complete, the commissioner will follow up if necessary.
Okay. No, I wanted to say that it is for the commission to decide the way forward. All that I can say is that the complaint was lodged on the day in which the matter was supposed to be heard, which was the 2nd of July. I have not formally been informed about any movement. As a matter of fact, that's why I say I've been informed. But the JCC has not communicated anything with me, and today is 1 day shy of 3 months.
Thank you. Now, the Free State province is a vast province. I don't know it that well, but I do know that Parys, a town like Parys, is 300 kilometers removed from the seat of the High Court.
A little bit less than 300, but it is far.
It is a bit far.
Yeah.
Now, in matters criminal, one would understand that there would be the circuit courts with a view to taking the criminal justice to the people that are far removed from the seat of the High Court. But what is the situation in respect of civil matters?
In respect of civil matters, all civil matters are dealt with at the Bloemfontein Court. And there again, the reason therefore is attorneys and litigants involved in civil litigation can appoint correspondents in Bloemfontein to assist them in the filing of matters and dealing with those matters. And it is then just on the trial date itself that the parties will have to come to court to testify, whereas a different consideration applies with your criminal matters.
Is this not a case that is crying out for intervention in the way of access to justice from the civil side? And if so, what measures do you have in mind to alleviate that difficulty in access, if I may call it that?
Yeah. Thank you, Commissioner. Fortunately, the Minister is present. The whole idea of deputy judges precedent, when it was mooted for all the courts, because previously only a few courts had deputy judges precedent, it was also indicated that a province like the Free State might justify 2 or 3 judges precedent, but they would then be decentralized. In other words, you'll have a judge president in Bloemfontein, a judge president in Welkom, and probably in Bethlehem. And in that sense, yes, in future there would be ample room to make sure that there's access to justice, but you must also remember you have an infrastructural problem, because then the court must permanently sit at that particular seat. As things are now, in Virginia, sometimes the High Court sit in what I colloquially call a bunker. It's in the basement. You sit at a bench, probably smaller than this, and there's some makeshift dock for the accused person. Those are the circumstances under which high courts operate in the Free State. Now, if you add that, you have to cost it properly. There must be the necessary infrastructure to achieve that. But in principle, I have no problem with it.
Well, in closing, Chief Justice, I guess my question to you is that applying as you do for a leadership position, do you have a plan to ensure that there is access to justice, considering the scenario that I've painted to you?
Access to justice in civil matters?
Yes.
Well, that is something that I will surely consider. But as I've said to you, the challenges and constraints are too many to say, well, it's something that will be implemented. But to consider it, yes. Yes, I have no objection to the idea. That is why I thought about all the challenges to it, because I have also considered it in the past.
I was hoping for a plan, but thank you, Justice. Thanks, Chief Justice.
Thank you, Commissioner. Commissioner Singh?
Thank you very much, Chief Justice. Good afternoon, Commissioners. I've been covered by Advocate Nkosi Thomas on the one question on Judge Slopper. Thank you. But just generally, good afternoon, Judge Musi.
Good
generally
afternoon.
and not specific to you, I mean, the Chief Justice mentioned the Public Office Bearers Commission for Remuneration that you chair.
Yes.
And you didn't appoint yourself, you were appointed.
Yes.
And the Act makes provision for a judge. But just a question, do you not see the appointment of a judge to chair that commission as a conflict of interest? Because in the end, you're also making recommendations on your own salary.
Thank you for the question. Well, the Act does not make provision for a judge. It's a person. But the practice has been to appoint a judge. But the Act has its own inbuilt checks and balances, thanks to the wisdom of the legislature. Because what has been said is, if it's a judge that is indeed the chairperson, those recommendations must ultimately go to both houses of parliament when it comes to the salary of the judge, because otherwise you will have a conflict of interest if the judge gives him or herself 20% and members of the legislature 10%. So the inbuilt checks and balances, if it's a judge, it must go through both houses of parliament. So chances there for the judge to have that conflict of interest is minimized, if not eradicated, because the legislature can always say, send it back.
Thank you, Chief Justice.
Thank you, Commissioner Singh. JP Leo?
Thank you, Chief Justice. Good afternoon, Deputy Justice.
Good afternoon.
President Musi.
Good afternoon, Justice Leo.
I just want to find out, as you allocate cases to judges, which factors do you take into consideration in order to ensure equal distribution amongst them without compromising the output or the finalization of cases?
Thank you, Judge President Leo. Firstly, it will always depend on the kind of cases that must be allocated. We are a very young bench. Of the top of my head, yes. I think 6 of the judges of that division have less than 5 years experience as judges. 3 of them less than a year. So I even consider that. So to me, it's not the equal allocation as in numbers, but substantively equal in the sense that if I give a particular judge a very involved matter, because I go through the matters, I give Judge A a very involved matter, and Judge B, I would sometimes give 2 applications for a summary judgment. I balance it out. I consider all those things. For instance, if it's rough matters, I give to the judges equally.
Commissioner Malema?
Good afternoon, Judge.
Good afternoon, Commissioner Malema.
Is there a complaint against you by Judge Tope?
I was told that there is a complaint.
No. Is there a complaint against you by Judge Tope?
It's difficult to answer. Let me say yes, for all intents and purposes, because I have times without number inquired from the admin people, and they said, well, there is such a complaint, and they don't know how far is the process of it. So let me say yes.
No, but if there was a complaint, how are the complaints presented to you guys?
What happens is a complaint is lodged at the JCC. The JCC would then write to the judge concerned and ask the judge to comment on the complaint. And that would be the time that you are notified, and then you comment on it.
Has that happened?
No, it has not happened with me.
In the absence of that, is there a complaint against you by Judge Tope?
Factually, there still is. The process has not been followed, but there is, because I've inquired from the JCC Secretariat, and they say, yes, there is such a thing, but according to me, I have not been informed officially of a complaint. So from where I sit, I can say to you, well, there isn't, but factually that won't be correct, because I have inquired and I was told that there is such a thing, and I must just accept their word on it.
Thank you.
You know, what is the meaning of "I don't suffer fools gladly"?
Well,
what does it mean?
Well, in the context of that I have used it, CJ, is firstly, I am a person who is straightforward. Secondly, if I see that a judge has been remiss of or a judge does not do what he or she is supposed to do, I go to the particular judge and I tell the judge, look, this is not on. You must do this, that, and the other, because you are here to do the particular job.
Yes. You see, I'm asking because I thought I knew what it meant until I looked it up. And the Cambridge Dictionary says it means to become angry with people you think are stupid.
No.
So I wanted to be clear that you don't see others as fools because they may not know what you know, and therefore you deal with them in a particular manner.
Yes. No, definitely not. That's not the connotation here.
Yes, yes. No, thank you very much. Your excuse.
Thank you very much, CJ, commissioners.